morning, particularly to Dame Antonia. You're very welcome, all of you. So today, welcome to the Public Accounts Committee, 9th of January 2024. We are examining the Crown Court backlog, which has reached an unprecedented high, we think, from the figures of 73,105. Were unheard at the end of September 2024, representing a 10% increase on the previous year and approximately twice the figure in 2019. So long waits for cases, as the Bar Council says in evidence to us, is having a very serious effect on defendants, witnesses and victims, including victims' mental well-being and deteriorating well-being, and an increasing number of defendants spending long periods on remand awaiting trial. So today we will question our witnesses from the MOG and HMCTS on what they have done to reduce Crown Court backlogs and their understanding of the wider impact on victims, witnesses and defendants. We will also examine what the MOG and HMCTS are planning to do to reduce this Crown Court backlog and address the unacceptable delays into justice for all those involved in the justice system. Just to let everybody, including our witnesses and anybody else who may be attending this session, that we will be having an informal 5-minute only break after about an hour into our public session. So with no further ado, I'd like to extend a very warm welcome and hope that all our witnesses had a happy and new year. So particularly to Dame Antonia Romeo, who is the Permanent Secretary of the Ministry of Justice, joined in 2021, so you have corporate memory of all of this. To Nick Goodwin, who is the Chief Executive at HM Courts and Tribunal Services. You were also appointed Chief Executive in March 2022. And finally to Jerome, Director, General Policy and Strategy Group, MOJ. Jerome was appointed permanently as Director General for the Ministry of Justice Policy and Strategy Group in August 21. I don't have any piece of paper about you, Daniel, but it's going to my memory is going to be refreshed hopefully very shortly.
I'm Daniel Flury. I was appointed Operations Director in HMCTS in 2023.
Brilliant. Thank you very much for that. So welcome all of you. Let's go straight into the session. I've got a very soft question for you, Dame Antonio, just to get us used to questions. Do you agree with the old legal maxim that justice delayed is justice denied?
Well, certainly yes, and in particular I note that the Lord Chancellor reaffirmed her own strong view that justice delayed is justice denied to the JSC, for which I see we have the chair here today in December.
So, without a huge long answer, can you very briefly, almost with sort of just sketches on each item, but very briefly, tell us what you're doing about it, and then members of the committee will come in on all of those aspects, I've no doubt.
Well, Chair, first of all, thank you for having us. If I may, just to quickly set the scene on what has happened on the outstanding caseload since, as you say, pre-pandemic level, where it was, in 2018, it was at a sort of record low. Obviously, the pandemic itself led to a significant increase in the caseload, up to about 58,000, a little over, in March 22. Actually, in October 21, it was at 59,000, and that was when we set the original ambition that by March 25, we would try and bring the caseload down to 53,000. So that was then, we were sort of on track to begin to do that post-pandemic. Then, of course, the CBA disruptive action did indeed add a number of cases into the caseload, the outstanding caseload. So it started to go up again significantly, combined with the harder case mix that had developed as a result of the cases in that outstanding caseload. That meant, combined with the significant increase in receipts from demand, from the new demand coming in, for example, from the additional police being recruited, meant that the caseload continued to go up. So as you say, it is now at a record high of 73,000. In terms of what we're doing to reduce it, there's a sort of clusters of things that we do. There's ensuring we have the physical capacity to do the work to bring the caseload down and to do as much as we can within the funding constraints on sitting days. So that is about having physical capacity in the courts. It's about having additional Nightingale courts where needed. We can say more about that if needed. We've done a huge amount of judicial recruitment, which in the past had been constraints in some areas, particularly been running major recruitments on for circuit judges and recorders. And then it's about some policy things that we can do. For example, in November, we increased the magistrate sentencing powers back to 12 months from 6 months. So it's partly about looking at what we can do within our current arrangements for some diversion out of Crown. So we're very much focused on that. And then the other thing that the government has recently announced is the Leveson Review, which will look at what more can be done to try and divert out of Crown, to focus on, within the constraints of needing to have a fair trial, bringing down, looking at diversion where it can be done, and to reduce timeliness, and in particular to also look at efficiency. And I should say the reason that we do all of this is because we recognise the real world impacts that delays have on victims. It's very serious. The Lord Chancellor has been, and the government, been very clear. They want us to focus significantly on this.
That's a very helpful introduction for us. Thank you for that. So to start to unpack all of that, I'm going to call on Oliver to ask the first question, please. Oliver Ryan, please.
Thank you, Chair, and thank you, Dame Antonia. You've sort of answered this question in your sort of opening statement, but in 2021 you assured us, as you say, that you get the backlog down to 53,000 by March of this year. And you've mentioned there the pandemic, industrial action, demand and additional complexity. So as a kind of second layer, if you like, to build on the question I was going to ask, which is why haven't you met it? Is it purely an issue of kind of capacity, and there were issues in the system like the pandemic and the strikes that meant you couldn't meet the sitting day targets that you wanted to meet, or what was the inbuilt reason for that, kind of logistically, that you didn't meet those targets?
So I think it's different things at different points, really. And I mean, the fundamental unanswerable point is that the demand on the system is greater than our capacity to dispose of that demand. So receipts are increasing significantly, and the ability to dispose of that has not kept pace. So that is why, therefore, the outstanding caseload goes up. There have been at different points. We have had in the past during the pandemic, there was a physical capacity constraint. There was at one point a judicial capacity constraint. Now, and obviously the significant inflow from new demand from the police has meant that we're constantly trying to put in place the ability to manage this influx of demand. But I would say that what the government has recognised is that even with all the with all the money in the world, at this point where we are, given what's happening in the trajectory, it'd be very difficult to get back into line, which is why we are looking at what can be done by the Leveson Review. We've asked Sir Brian Leveson to look at what can be done with some bigger reforms in terms of what comes to Crown. I would also, if I may, Ms. Ryan, just take this opportunity to say I want to pay tribute to the work of people who work in the courts who have fought to focus, Crown, but as well as all jurisdictions and indeed colleagues across the whole justice system who have fought to try and get this down into line. We're all very focused on it to bring the backlogs down.
So, and do you know, as we sit here today, what the current backlog figure is? We've got the 73,000 figure for September, I think, of last year. What is it as of now?
Well, we say, we're working with 7,105. We don't, because the next figure will come out for December. I think the figure comes out in March. So we always work, because we obviously, as we have learned, and I'm sure we'll get into this, we have to assure the data before we use a figure publicly. But if anything, my expectation is it will be higher.
Right, okay, it'll be higher again. It's a worry because, people kind of get into this, I suppose, as we go through, but it's the wait for victims and the wait for justice that concerns us most. It's almost not the procedure of the legal process, it's the really harrowing stories that we've had through different written evidence to the inquiry, which has said that, to the committee, which has said that people, as was referenced by the Chair, waiting for justice often suffer because of that wait. So what's your current ambition for the level of open Crown Court cases, and do you think that you can get to the 53,000 that you wanted to get to?
Well, as I think the Lord Chancellor has said, as of where we are at the moment, the number is not going to, it's definitely not going to come down to the previous ambition of October 21 by March 25. Oh, no. But I also, given where we are at the moment, I wouldn't want to make any predictions of when we would get it down to that level. It will depend crucially on what comes out of the efficiency, the Sir Brian Leveson efficiency review.
Thank you. Just one more, Chair, if I can.
Yes, of course.
There's different issues touched on the sort of further questions that members have got, but there is something to be said for the industrial action, as you say, and the effects of kind of legal aid cuts over the last few years. I think something like 48% or something of government cash was pulled out of legal aid, and that's obviously caused issues with processing cases in the courts. But there's also a figure in the NAO report which mentions something like 27% of cases were ineffective in courts in 2023, which is particularly concerning because you are allocating them sitting time, you are trying to process them through the system, but they are failing when they get there, which seems like a little bit of a missed opportunity, that if these cases were more effective, you'd be able to get them through the system quicker.
So I know that Nick and Daniel will want to comment on the ineffective trials in particular and what has driven up the rate. Obviously, as the throughput, so we've been running the system much hotter. So the number of sitting days has been going up. And as that happens, you do tend to see an uptick, therefore, in ineffective trials. As the report sets out, there's a number of reasons for that trials are ineffective. And I think that the Leveson review in particular will tackle what is seen as the second point in the report, which is poor case preparation, because a lot of it is about case preparation and how you can, the things we can remove from the system that make the case management flow more efficiently and better. So I think there are some things that we're doing specifically that will help with that. But if I may, I might ask Dan and Daniel and Nick to say something about ineffective trials in particular.
Yeah, just to say that the rate is currently 25% through published in the latest stats. That is far too high, and as Antonia says, it's a symptom of the heat in the system. It's principally caused by defendants being absent, the defence not being ready, but also our desire to maximise court time in the Crown Court by listing, in some cases overlisting cases, to ensure that we can get on as many as possible. In terms of what we're working closely with the judges to look at that ineffective trial rates, and in particular there's a judicially led assessment of listing policies in the Crown Court underway at the moment, which we expect to report in the spring, which will look at ways in which we can reduce that rate further.
Can I just check, Dan, because I don't want to take too much time on this, because I'm cautious I've kind of probably overstepped the first question, but did you say it's currently 23%? 25, and that's down from the 27 that we've got in here?
It is, yes.
So it's improving in rates. Okay, great.
Sorry.
Right. Nestle Kaliskin, please.
Thank you very much, Chair, and thank you to the committee. For setting the scene, we know that the backlog in 2019 was just under 40,000, and it rose by 60% by June 2021. That is pre-COVID, so there was already a rise in backlog of cases.
June 21 was post-COVID.
Post-COVID, but the COVID period, it included pre-COVID period too. So is it fair to say that there was an increase in backlog of cases pre-COVID also?
There was an increase in the outstanding caseload, yes, from memory, it was about 33,000 to about 38,000 between 2018 and 29. Is that right?
Yeah.
So there is an acceptance that there was a trend already in
from a record low, yeah.
But the trajectory was going up pre-COVID too. The reason I'm asking that is because there was £477 million that was given to the department so that the COVID backlog could be dealt with. I just wanted to probe that a bit more to understand if it was just for a COVID backlog or if it was also to tackle what was an increasing number of cases pre-COVID.
Right, well, let me say something and then I can see that Nick wants to come in. So first thing to say is the £477 million was for overall CJS recovery. So it didn't all, as Nick will be the first to remind me and doubtless the committee, it didn't all go to HMCTS for that purpose. So it included things like So in HMCTS, it went on things like Nightingale courts, video hearings, additional sitting days, etc. But also it went for money on legal aid for the appropriate cases, on the probation caseload, and also a significant proportion of it went on the new prisons that we were building, so the medium-term estate strategy, so new prisons and the resource to run those prisons. So that was the money we were given in that spending review. So that is not, all that money did not go to HMCTS for, in particular, focusing on the reducing the backlogs, if that's your question.
But the overall, they are all interlinked, aren't they?
Of course, yes, yeah. One big system.
Did you want to add anything to that?
I was just going to clarify some of the financials. So of the 477 million, about 42 million pounds of that was directly at the courts. So on the criminal courts side of things, and that was required to do things like have Nightingale courts, more video hearings, more cleaning and so forth. We also had a pot of money, if you like, COVID money of around £65 million about the same time. So in total, for the courts, we had about £107 million to deal with both COVID and COVID recovery. And as I say, that was very much to make sure that the physical space of the court was safe and that we could sit trials there, and to help us fund the activity, increased activity, more sitting days to get through the backlog.
And the reason I ask is because there is a strong view from barristers, isn't there, that actually by not including or acknowledging pre-COVID figures, there is a false economy, I think is the phrase that they use, that we must recognise the trend pre-COVID of the backlog.
Well,
there was a Guardian article in 2019. I think there was a further article in 2020. Barristers have been quite articulate in accusing the courts of a false economy, as I say. It's a phrase that they use for not tackling the backlog in 2019 prior to COVID.
I'm not sure about any more detail on the false economy and what exactly is meant by it would be really helpful. I think there's no suggestion that there's any attempt not to be clear about the figures. So we're very clear what was happening with the backlog before.
No, certainly.
It was at a record low, it went up, it was going up a little bit, but obviously that's nothing compared to the 38,000 to what it's now ended up being, well, indeed what it was post-COVID, so in October 21 when it was 59,000. That's been the significant rise. I don't think people are saying that... But
there has been a long-standing issue of that was exacerbated by COVID, but there is a view that there was a longer-standing issue. I mean, if you don't agree with that, that's fine. I'm just trying to understand.
I think it's hard to say it was exacerbated when the massive amount happened during COVID, but I definitely acknowledge that it had gone up a little bit pre-COVID, absolutely. And Jerome may want to...
The reason I'm probing this, Chair, is because if there is such a significant figure in terms of a backlog and the department officials are being asked to come up with a new way of dealing with this, if it is a temporary issue because of COVID, then that might dictate what structure or systems you put in place as to how you deal with a backlog compared to what might be a longer term issue because there is just more flow of cases coming in. So if it is the view of officials that actually it is COVID related, it is only temporary, that's one view that may dictate how you then move forward. But actually, if there is just a general trend that cases are increasing, then I would want to, that may indicate that there needs to be something more fundamentally in the approach and how you deal with cases coming through the system.
So it's a good point, and it is the latter. There is obviously, I mean, what's happening is, as I said, demand is outstripping our ability to meet that demand. It's not just a temporary issue because of COVID, although that did originally cause that increase in demand. But Jerome...
Well, I just wanted to just pick up on your point about it being a long-term trend. I think actually the trend in the years up to, so as the Permanent Secretary said, it went down, the backlog went down to about 33,000 in 2018. In fact, the trend prior to that had been a reduction from 2015, it was at about 51,000, it came down, and then it came up a little bit pre-COVID. But as the Permanent Secretary said, COVID completely blew that out of the water. And I think that there are two things going on, as we said. So the first is COVID was the thing that really structurally changed things. But in addition, now we've got, and the CBA strike as well. But additionally now we have the additional demand coming from the extra police officers and the structure of the crime and the receipts coming into the Crown Court is quite different as well. So it's not just a COVID.
They're not temporary measures. They're fundamental policy changes that dictate the number of cases coming in. That is different to a COVID period where there would be a temporary demand.
I think that's exactly right, and that's why why the Lord Chancellor has launched the Leveson review, and why we accept it's a structural issue that requires a different way of thinking, and that's what we've asked Sir Brian Leveson to look at.
My final point, Chair, is that given what you've said, do you accept that there was a lack of joined up thinking between the three levels of justice, if you like, so policing, courts and prisons, which has meant one of the impacts is there was this huge backlog?
Would you mind... thank you for the question. Would you mind saying when you think the lack of joined-up thinking occurred that led, and to what extent a lack of joined-up thinking led to the
policy
backlog?
Decision is made around policing, for example, which would lead to more arrests, then that would inevitably mean more people will be charged and there would be pressure on the courts. Was that not planned for?
It was planned for. In fact, in SR 21, we were explicitly given money for the fact that there was going to be additional demand on our system coming from the fact that the new police were being recruited. So it was understood, the end-to-end system approach. And as Sir Geoffrey knows, I'm very happy to talk at length about the Criminal Justice Action Group, which I chair, which involves
on to that next.
Okay, good. I won't give a spoiler now. But we work really hard to join up across the whole system. And it was understood at the time that the police were being recruited. I think the point that Jerome was making is it's not just about the new police. It's also about things that happened that we hadn't entirely predicted. So the fact of COVID didn't just add approximately 7,000 cases into the caseload. It made that case mix much harder, as we call it, which means those are cases that are more difficult to handle.
But the two things that were temporary, the strikes and COVID, are over, and the numbers are continuing to increase.
Right, but as you'll understand, the lag that is triggered by something like a case mix becoming much harder and 7,000 additional cases being added to the caseload can't be fixed overnight. So the lag is quite long. But just to be clear again, I'm not suggesting that this is a temporary problem. The problem is that the demand coming in is not being met. We do not have the ability to dispose of the cases that are coming in at the rate that they're coming in. That's why the caseload is increasing.
I understand what you're saying, but there does seem to be a contradiction. You're saying that there was a plan. I mean, if there wasn't capacity, if there was a plan, it can be. Both things can be true. That you can plan well, but actually a government just doesn't give you the resources enough. Those two things can be true, and if that is the case, it is helpful for you to say that to us. Or actually, it doesn't matter how much we planned, and at that moment in time, we did have enough resources, but we had two things: the strikes and COVID, which have made things very difficult, which is why the numbers increase. And I can accept that, except there has been considerable time since those two things, and actually the caseload isn't coming down. Now, if I'm wrong about the latter, I'm happy to hear why I am wrong, but my understanding from the figures are that the caseloads are increasing, and I think the committee needs to understand, and I think we'll come on to the amount of money that's been spent. Given hundreds of millions of additional monies have been spent, how can we have confidence that actually the caseloads will come down? So that's the context in which I'm asking the question, but I will leave it there, Chair. Thank you.
Well, thank you very much for probing the historical genesis of all this. So I'd like to now move on to Clive Betts to talk about rise in legal aid fees, please.
Yes. The independent review of criminal legal aid. Didn't the fact that you had to have a review indicate the department had rather lost a grip of the situation?
The fact that we had an independent review of criminal legal aid?
Yes. It indicates that something is wrong that you set up an independent review, doesn't it?
Well, I mean, I think to some extent the government can choose to have reviews to look into in more detail what needs to be done. I think what happened in that case was that it was understood that obviously on a historic basis changes had been made to legal aid. The government at the time listened to what practitioners were saying and therefore set up an independent review under Sir Christopher Bellamy to look at what had happened, and that review made recommendations, and the government is in the process of responding to implementing those recommendations?
Before the review, between 2008 and 2021, legal aid fee rates had reduced by 1/3. That seems to indicate there will be a problem, doesn't it? I mean, there's something going on there which you're not dealing with on an ongoing basis, isn't it?
I mean, I know you won't, Ms. Bex, you won't expect me to comment on policy of an administration, many times previous administration. I mean, policy decisions on legal aid rates are something to which the response, clearly, the practitioners had a view, things happened in the market, the response, therefore, was the independent review.
It was causing problems, wasn't it, a long time before you actually had the review?
Well, I mean, not being around at the time, but I would indicate that the fact that practitioners are saying, practitioners are saying that were obviously saying that there were problems, and that was what led to the review.
So you set the review up because there were problems?
Well, I mean, Jerome might remember.
I guess in terms of what it means for the Crown Court backlog, I mean, clearly what has been happening over the long term is there's been a reduction, it's talked about in the report, a reduction in the number of crime barristers and indeed criminal solicitors. And so the review was in that kind of against that sort of backdrop, looking at, what are the things that we can do potentially to address that. So there's an enormous amount of data in that report about exactly how do we, how many barristers are there, and trying to get to the bottom of it. So actually one of the positive things to come out of the report as well is that we now are much better at sharing data between the Bar Council and the Law Society, and so we have a better understanding of exactly what the picture looks like. And it's also fair to say that since we've taken action, both in 2022 when we responded to the Criminal Legal Aid Independent Review, and indeed with the subsequent actions, what we've seen is actually now an increase again in the number of barristers. So that's a kind of positive development. So to your point, was there a historic problem? I mean, I think, we that was exactly what we wanted the review to look at. It made some recommendations. We've acted on the recommendations, and the recommendations appear to be working.
Okay, we'll just come on to that in a second. But so basically, before the review, you didn't really know what was happening. You're saying that you hadn't got enough data to do assessments of what was happening.
No, I think I wouldn't. I think what I would say is we did a review in order to get the right understanding of exactly what policy measures we wanted to put in place. I mean, whether or not it was working, is also slightly. It isn't quite the question. It's more, how do we address the issues? And that's what the review was trying to do. It was trying to get to an understanding of what the actual picture was. Because prior to the review in 2018, we put some money into criminal legal aid for the barristers in particular. And what we were trying to do was, before putting in more money, and we've put substantial investment since then, 141 million in 2022 alone, before putting in more money, we wanted to know where best to target it. And that's, to me, it strikes me as it's the right way to do it, to have an independent review to look at where to put it, and then we put the investment in.
So you had the independent review, and then it took you a year to implement it.
Well, we responded to we consulted, we responded to the consultation.
So changes in legal aid need to be consulted on, and so what we did was we considered there were a large number of recommendations in the review, and so there were 19 recommendations, if I recall correctly, and so we wanted to make sure that we were kind of taking action. Not all of them were about fees. In fact, a lot of them were not about fees. So so in our full response, we consulted with an interim response the year after, in I think June 2022, and then we did a full response in November 22, and then we've been obviously implementing the changes since then. But it's a detailed report. It's a very, it takes a long time to kind of consider the recommendations of it.
In hindsight, this was a problem a long time in the making, with little effort to address it until the review and then the recommendations being implemented. All right?
Well, I suppose it's obviously, it must be true that the fact that the review made recommendations that we're now implementing means that there were recommendations to be made, i.e. there were improvements that could be made to the system. So, yes, I think it must be right that there needed to be improvements, and we're trying to make those improvements now in responding to the review. As Jerome said, an original 141 million, significant fee uplift since then, both for solicitors and barristers, and very importantly, the setting up of the Criminal Legal Aid Advisory Board to look at. So you might be about to come on to that, I expect.
Well, just onto the 50% rise. I'll just deal with that particular point. Has it worked? Has it solved the problem?
Well, again, I mean, Jerome will want to say more. I think on the what we have seen on barristers is that the number of barristers on all crime and on is it called fully practice or the certificate for over 80% crime? On any crime and on over 80% crime has gone up. So if you mean, is it working? Is it working in terms of reinforcing numbers in the profession? I would say yes on barristers. On solicitors, it's stabilising, but we've just recently announced an additional 92 million at the end of last year, so that won't have had an effect yet. So we expect that will also make a significant difference.
Was it sufficient, the increase, to deal with the problem?
Quite early to tell, but go on.
Yeah, can I add just another data point, which is we talked earlier about the number of ineffective trials, and there's a bit in the report about the number of ineffective trials that are ineffective because of a lack of prosecution and defence barristers, and certainly what we were seeing was an increase in that, and the report talks about this, and now what we're seeing is a beginnings of a decrease in that. So again, as a data point, is it working? I think it's, as you say, too early to say, but that's an interesting data point that trend has begun to kind of move the other way.
Thank you very much, Mr. Glass. Let me help you a little. Can I give you this opportunity to put on the record with the information that you kindly sent to us and which we have published today, I think, Clark. Firstly, you did refer to the increase of 12% in solicitors' criminal legal aid at a cost of 92 million. Can I confirm that is what you've now implemented?
Yes, and to be clear, that's 12% on top of the 12% that we put in place for solicitors from Clare. So it was 12% from the original report and then 12% that we've announced in December.
With a little bit of luck, that will have the same effect as the increase in legal aid for barristers. You might help encourage more criminal solicitors into the system.
I mean, and that's very much that's very much the thinking behind that work. It's also worth saying that we quite recently, last year actually, we just implemented a £24 million increase, really targeted at police station in particular, which is where we were seeing some of the particular kind of problems, duty solicitors and police stations as well.
Very helpful, thank you. You also very kindly sent us on the 29th of September, which we published today, the increase of 10% in the Immigration and Asylum and Housing Department legal aid. You didn't give us a figure on that in the letter. This committee would always welcome figures if you send us information like that, but if you just very briefly explain that.
So that is in civil legal aid. So we've been conducting, alongside the criminal legal aid, we've been conducting our own review of civil legal aid, looking at the state of the market right across civil legal aid, and this flows all the way back to the changes that were made in the LASPO Act in about 2012, 2013. I can certainly try and see if we can get you a figure for that, but certainly
he likes figures.
Yes, okay. But 10% is what we're applying. The amount of spend will be something that we can come back to.
I'm now going to welcome the chair of the Justice Committee, Andy Slaughter. You're very welcome to our committee. You're going to come in on the next question. Can I just say to you and to everyone else, if there are any interests that should be declared, you should do it before you speak. Chair.
Thank you very much, Chair. Thank you for permitting me to join your committee this morning. I should say by way of declaration, so I'm a non-practicing barrister. Good morning to the witnesses. I do want to pursue this issue over funding, of course, and particularly over legal aid, but could we just go back one step? You've already mentioned, I think, the Leveson Review 3 times. Now, that's to be welcomed, but is that your solution to the Crown Court backlog? Because it does rather seem that you're betting the house on one report, and a report that is the inquiry is just starting. It will have to report. It will be controversial, I think that's reasonable to say, if it's proposing significant changes to the way the criminal justice system works. Then you've got to implement that. How long is that all going to take?
So I think the first thing to say is I don't see it as just a report. What it is going to be a fundamental look at reforms that we can make in the longer term. But it's not a. But I expect it will be wide-ranging and important in what it proposes. The other point I would make is that you've got to look at the whole system as a whole, and this comes back to the point that Ms. Calliscan was making, which is we have to. Everything is connected. So courts, prisons, probation, indeed police. So we never look at what we're doing. We can never look at just getting down the Crown Court backlog in isolation. So there's a lot of other work that we're doing. But as I said at the start, Mr. Slaughter, there's a lot of work that we're doing, not just waiting for that. The work extending magistrate sentencing powers, things like that. We expect that will save in the steady state about 2,000 sitting days. So things we can do already pre the report we're doing. We're looking constantly, and Nick and Daniel might want to comment on work we're doing to essentially improve efficiency and productivity in the courts, because at the end of the day you've got capacity, you've got the demand coming in, you've got the capacity to deal with it, and then you've got the rate at which you can deal with it within that
I would have thought
capacity.
You would have put it that way around, that you would look at what are clearly the problems in the system as it is. So that might be the fact that rather than any one day 1 in 5 courts isn't sitting. You've got this peculiar situation where you've got Nightingale courts still running, presumably because you've contracted to hire the accommodation and set up the staffing there, but you've got 1 in 5. My committee was at Snaresbrook just before Christmas, and a quarter of the courts there, 5 out of 20, weren't sitting. That's typical, I think, across the country. Why aren't you looking at that? Why aren't you looking at recorder sitting days? Why aren't you looking at, as you say, inefficiencies, like the Serco contract that doesn't deliver prisoners sometimes till late afternoon to court? Shouldn't these be the priorities in sorting things out, in getting the backlog down now, rather than something that might take 2 or 3 years to take effect?
I mean, I don't think we're disagreeing, are we? I'm saying there's a lot we're doing at the moment. In fact, I started, in response to Sir Geoffrey's question at the beginning, by setting out the things we're doing on physical capacity, on judicial capacity, and on efficiency now that we talked about, and Nick and Daniel want to say more. I'm just saying, because you started with the question, Mr. Slaughter, on what about the Leveson review, aren't you putting too much on that? I then mentioned that to say that I thought that was going to be important. Obviously, we can't wait for new big reforms. We've got to do a number of things now, and that's what we're focused on. I do think we don't lose, we lose something like 0.2%. I mean, Dan will be able to talk about what we actually lose through maintenance, through taking courts out of use for maintenance, is an incredibly small number because of the excellent work of court staff in moving things around. And I should obviously say that, the excellent partnership we have with the independent judiciary in doing that, and I'm very grateful to them for all the work that they do. The final thing to say, and then I will hand over to Nick and Dan, is that we've got to, in thinking about the throughput and our ability to respond to it, it's absolutely essential that we do all these things together. Money is going to help. I mean, we did invest a significant amount of money in court maintenance last year and this year, and we need to continue to do that to improve the estate, and we do recognise that. But again, as this committee, of all committees, will recognise, we can only work with the money we've got, and it's taxpayers' money at the end of the day, and we've got to make sure we're getting value for money from it.
That's very much what it sounds like, because most of the things that I've mentioned, and you've now mentioned, cost money. Some of them, I would have thought it would be more efficient to use all the courts of Snaresbrook, because the judges can share the work out between themselves. You can take account of crack trials and things of that nature, than have a Nightingale court up the road working. So there could be some efficiencies that don't cost money, but overall they are. If you're going to increase the number of sitting days, if you're going to try and ensure that there are more recorders available, more defence barristers, more CPS barristers available to conduct the trials, to really get into the backlog, that's going to cost money, isn't it? Whereas perhaps you think the Leveson review will actually save you money because you won't be having trials in the Crown Court anymore.
I think what I'm saying is I recognise we do the most we can with the money we've got. And we've got the money that we're given, and we try and run that as efficiently and as value for money away as possible. And Dan will say more about the balance between Nightingales, which are obviously much more expensive than the main estate, and that's why we've managed to close so many of them and switch back into the main physical estate. But recognising the money we have is limited. I mean, there's a very tight fiscal context. I can't hope for a magic money tree. I have to go with the money that I've been given, and therefore major reforms are also going to be essential because you can only work within the money you've got, and sometimes you need major reform as well to ensure to help you and to maximise what you can deliver within that money. But if I may, Chair, I'll bring in the Secretary.
Briefly, because we need to make a bit of progress.
It's worth saying a little bit about court capacity. So Crown Court capacity at the moment was a constraint in COVID. It's not a constraint now, the physical capacity of the courtroom. So we've got 502 Crown Courts now operating. So we're not constrained by the physical buildings at the moment. They're not the best buildings in the world, I think everyone knows that, but also we're not losing much capacity because of maintenance work. So we do lose about 2% of our Crown Court capacity, roughly, each year because of planned or unplanned maintenance. But what Daniel's team are incredibly skillful at doing is moving cases around the estate, so we only lose 0.2% of our allocated sitting days. So last year we only lost about 570 sitting days because of estate issues. So the physical estate, whilst not perfect, is actually adequate for the sitting days that we have. As Antonia says, there are financial constraints in terms of how hard you can sit the courts, but they have been sitting very, very hot. In June last year, they disposed of over 10,500 cases, and that is an incredibly high amount by recent standards. I think it's the highest amount since 2017. We'd like to do more, clearly, but even if you were to do somewhat more, the demand coming into the system is still outstripping the capacity of the system.
I don't want to outstay my welcome, Chair. One final point then. Did you say a moment ago that the number of criminal barristers is increasing now? Because our figures have shown that it's been going steadily down over time, as indeed as the number of criminal defence solicitors. And yes, there has been some uplift in fees, but judging from the mood of the criminal bar, certainly, there is still a great deal of anxiety, a great deal of lack of willingness, perhaps not to go into criminal law to start with as a pupil or in the first few years, but then to drift away. So don't you still have a crisis there in terms of recruitment, and what are you going to do about that?
Well, since Sir Geoffrey said that the committee welcomes figures, I can confirm that there were 3,615 any crime barristers in 23-24 compared to 3,429 in 2021. And in terms of self-declared full practice, which is working more than 80% workload on criminal, the number in 23-24 was 2,726, which was an increase on 2,424 in 2021. So it's going up. I mean, we mustn't be complacent. But I'm saying that the green shoots...
Still down over time. It's still down over 10 years ago.
Well, there's a lengthy trend in a way, coming back to Mr. Bett's question. But there's no silver bullet, right? We're not going to be able to solve all these problems at once. So what we're trying to do is to reverse long-term trends. And I think we're seeing some early signs, but very well aware I might be back in front of the committee on this exact topic in a year.
But it's your point that everything is linked. Unless all the elements are there, the trial doesn't happen, does it?
Exactly right.
So you really to come back on one really important matter that the chair of the Justice Committee mentioned, and that is a fundamental alteration to the system, which you set Sir Brian Leveson up to do. The Secretary of State for Justice announced this on the 12th of December, to look into the possibility of establishing intermediate courts. Now, this was looked at by Lord Justice Auld as long ago as 2001, so all the work's been done. As the Chairman of the Justice Committee says, you've set up Lord Justice Sir Brian Leveson to look at this. He, I don't know, is probably going to take a year to report. Then you're going to have to consult on it. Then you may or may not have to introduce these by primary legislation. Why don't you just get on and do it?
Well, I know the committee will expect me to comment on policy decisions, but in practice, in terms of timing, essentially there's two parts to the review. The first part, which is some of the policy things, because as you say, a lot of these things have been considered before, are going to be, I think Sir Brian is intending to produce his report in the spring this year. and then the efficiency part of it, which will be partly including looking back at the 2015 report on efficiency, will be in the autumn. So I think but there are a lot of everything we can get on and do, and particularly on the efficiency side. So disposal rates are higher now than they were pre-pandemic. Trying to, obviously lots of reasons for that, not least the more complex case mix, etc., but trying to look at where we can on improving efficiency. We're not going to wait for the report to
I get that. There's all these other things you can
Sorry,
do.
disposal rates are lower now, I should have said.
You can do all these other things that we've discussed and we'll discuss in the committee this morning. But the plain fact of the matter is that the total number of cases going before the Crown Court are increasing, the complexity is increasing, the number of days to hear them is increasing. So you have a fundamental problem, let alone all these other side ameliorations that you might do. So it does look as though you're going to have to do something fairly radical, like introducing intermediate courts. And so I think the Chairman of the Justice Committee again was driving at this. Too often government have reviews, and the reviews don't consider what resources need to go with them. So can we be absolutely sure that if Sir Brian Leveson did, for example, recommend introducing intermediate courts, that there would necessarily be the resources, the money to follow that recommendation if it were accepted by government?
Nobody will want to ensure that we have the resource required to do what's asked for us more than the Principal Accounting Officer and Ministry of Justice. So I would say, can I be sure we're going to get the resource? I don't want to prejudge the report, nor indeed what allocation I'll get in the next spending review.
If the government, I prefaced the question very carefully. I said if the government were to accept that recommendation, that the resource would follow to do it.
Then my strong advice would be that we should not accept taking on any recommendations without the resource to deliver.
Thank you very much. Thank you. So we then come on, as you predicted that we would come on, to the whole issue of Criminal Justice Board and why it was suspended between July 2021 and July 2023.
So obviously it's a matter for the Criminal Justice Board, which has been going for a long time, is chaired by the Secretary of State for Justice and Lord Chancellor. It's really a matter for the Secretary of State how they most want to engage with partners. I mean, it's envisaged to bring together the partners in the criminal justice system to set the strategic direction, and some Secretaries of State have wanted it to meet more often than others, and some have found it more useful as a forum, and others have wanted to engage more bilaterally. I think the Secretary of State at the time preferred to engage bilaterally than to bring together those partners in the form of the CJB. And when those things do happen, there's obviously other governance in place. So not wanting to constantly refer to the Criminal Justice Action Group, but that was a group that was set up of senior officials with partners, the police, the CPS, etc., to bring it at an official level to look at the governance and join up across the system.
Right, let's just cut to the chase on this. If you look at figure 6 on page 28, you can see how the Criminal Justice Board is made up. And it's made up, it's not only chaired by the Lord Chancellor, the Secretary of State for Justice, but it includes such very important people as the senior presiding judge, the President of the King's Bench Division, whereas the Criminal Justice Action Group that you chaired doesn't have any of those senior representatives. And this was at the point when the whole system was getting into crisis. So why did the Criminal Justice Board not sit continuously during that period?
Well, the decision of the Secretary of State at the time was not to convene the Criminal Justice Board for which he was the chair.
Okay, that's a perfectly straightforward answer. Thank you very much. That's all we need.
May I just make a comment on attendance on CJAG? Because as you rightly say, the judiciary are not on it. We did invite them to attend, and indeed the SPJ at the time attended the first one, but then quite recently felt it was a very executive group because it's made up of officials, so it felt it wouldn't be appropriate. But the head of the Judicial Office has for the past 6 months been attending the Criminal Justice Action Group, so we do try and join up as well with the judiciary.
Well,
I accept it's not the same at the same level.
I hear that answer, but then things did start to improve when the Criminal Justice Board reconvened. Anyway, Clive Betts.
Just very briefly, a follow-up from Nezel Carliston's questions earlier about the extra money that you were given in 2021 spending review, 477 million. Did it all get spent on reducing the backlog? Or if not, how much did get spent?
So it's quite hard to talk about exactly what goes on reducing the backlog, because to some extent all money spent on the Crown Court is focused on getting cases through the Crown Court, and that is focused on reducing the backlog. So is the question, was all the money spent on the Crown Court? The answer is no. As I already set out, that included money for prison build. That was capital and resource, by the way, the 477 referred to. It was money for prison build and the running of those prisons. It was money for legal aid. It was money for probation caseload as well. So, I mean, Nick can talk about what money during that period was spent on the Crown Court in particular, if that would be helpful.
Yes, it would, but in the end, the 477 million as a total figure was there to get the backlog down, essentially, wasn't it? That was the focus of it.
It was for It was actually for CJS recovery, so it wasn't just focused on the backlog.
So the backlog was an absolutely crucial part of that.
Crucial part of it, but not the only part.
Okay, so do we know then, if it's not the only part, how much of the part the 477 million was actually spent on dealing with the backlog?
Yes, I think so.
So, I mean, I can talk about the courts part of it, which, as I said before, that 477, about 42 was focused on the courts. And we had another 65 million for COVID recovery generally. And we put that money together, if you like, and some of the 65 covered other jurisdictions other than the Crown Court. But in relation to the Crown Court specifically, the money was spent on additional sitting days, so that's in part in response to the 20,000 police question that you had before. So £23 million was spent on greater activity in the Crown Court. During COVID and subsequently, one of the main tools we have at our disposal to get cases through more quickly is the use of video, and that was critical in COVID. And so we spent quite a lot of money, 18 million in total of that 107, on video in the Crown Court. We also invested in the Nightingale courts, less needed now. They are expensive, but we spent £28 million.
Part of the, sorry sir, is that part of the 100-odd million that you referred to, the spend of the Nightingale courts, is that part of the 100 million you've referred to, or is it a different amount as part of the 477? The Nightingale spend?
Sorry,
the Nightingale courts,
yes.
I think there's a total of, is it 78 million in total that's been spent on Nightingale courts? Is that in addition to the 100 and something million that you're referencing now, Nick?
So the figure that I'm quoting from is from that pot of the 65 COVID recovery in 42. Additional spending on Nightingale. Can I come back to you? Sorry, it's quite...
Tell you what, to help you, Mr. Goodwin, we're going to have our 5-minute break as soon as Mr. Betts has finished his section. If you want to just think about that question and clarify it after the break, I'd be very happy for you to do that. Mr. Betts.
We've got a clear breakdown of what the 477 million was spent on,
yes,
and what it achieved. Because in the end, if it was supposed to achieve dealing with the backlog, it didn't, did it?
That's what the counterfactual is, of course. It was aimed at CJS recovery, and what it achieved. What it achieved was getting the courts back up and running, getting video hearings rolled out. You know, all the work that was done, paying for some Nightingales. I mean, those are the things that it achieved. Had they not been done or paid for, then the backlog would have been even worse than the additional 7,000 approximate cases that went onto the caseload.
It allowed the Crown Court to sit at its maximum capacity for the last 3 years.
Okay, so it did something, but not as much as it would have been needed to tackle the fundamental problem.
Well, I think sitting at maximum capacity is, to a certain extent, the best we can do, really, and that money allowed for that.
It didn't prevent the backlog from going up to the extent that it went up. I suppose that's the point. But to Dan's point, it did as much as it could.
Well, just very briefly, because I'm going to suspend.
I'm really, really brief.
Yeah.
So what you're saying sounds good, that it's sat at maximum capacity for 3 years. But if it's sitting at maximum capacity for 3 years and the backlog is still going up,
yep,
that tells us that maximum capacity is not sufficient to deal with the combination of factors that you have referenced. Mm-hmm. So one could argue that what is fundamentally wrong is not the money, is the very essence of how we run our Crown Court system in this country, alongside increasing police officers, not enough places in prisons. So what we're talking about here is actually non-essentially money or whatever. We've just got to the bottom of it. It's not good enough because maximum capacity isn't reducing the backlog.
Yes, I think we accept that, and this is why we looked at things like increasing magistrate sentencing powers, which we hope will take some of the heat out of the Crown Court, but also Leveson and all the things that we're doing in the interim between now and Leveson reporting that will bear down on inefficiency in the Crown Court to try to further maximise that capacity that we have available to us now.
That is Brian Leveson's starting point. It's broke, it ain't working.
Well, the fact of the matter is, even sitting at maximum capacity is not enough to arrest the caseload. The stats speak for themselves on that.
On that moment, it was worth waiting for Rachel Gilmore's question. It's a very good point for us to take our 5-minute break. It's now on the clock there, 10:56. Could we try and be back at 11:01 in our places? Can I thank everybody? Order. backlog. And I'm going to count down our... Sorry? We're back on. We're broadcasting, everybody would be glad to know. So I turn to Anna Dixon, please.
Thank you very much, Chair, and good morning, witnesses. So I'd like to pick up the issue around the length of time people are waiting. We've understood that the average time taken from the case sort of going to magistrates right through to completion of Crown Court has gone up from 158 days to 279 days. And I think since this committee's last report back in 2021, those people waiting for a year or more has risen to over now 18,000. Behind these numbers, obviously, there are victims, but also witnesses and defendants, all of whom are waiting. And we know the impact both on their well-being, but also on justice outcomes. And I in a way, going to start just briefly on justice outcomes. What evidence can you share with the committee about the impact of such long waits on justice outcomes? I don't know who to address this. Mr. Glass, thank you.
Yeah, so, I mean, the first thing to say is clearly that's not a desirable state of affairs, and we completely accept that. The timeliness has gotten much worse across all crime types. I think it is a particular concern with respect to sex cases in particular, which are often take the longest. Both adult rape and child rape cases. They are incredibly complex cases, but they are and require a lot of kind of disclosure of evidence and so on. But they are the most sort of serious cases in terms of the backlog, the sort of the timeliness point. I think in terms of the impact, so we know that the Victim Commissioner, I think, has just conducted a survey of the impact. So she's just recently conducted a survey of the impact on victims in terms of the thing that we particularly wanted to track is victim attrition through the system, i.e. are people pulling out of cases because it's taking so long, and that is exactly what she's going to look at, and I think she's publishing the results of that study next month.
You don't have any data on that currently, no, Mr. Glass?
Yeah, no, we do have data. So victim attrition has, broadly speaking, it has increased. Right. And for some cases, say for adult rape, it is particularly high. I think in the year to June 24, 59% of victims were dropping out pre-charge, and that has gone up significantly. And so what we have tried to do, would you mind can I go on to the things we tried to do about it?
Yes, please. I'll come back to some of the specifics.
Yeah, so one of the specific things that we've been trying to do is we know that there is good evidence that support through the system, so particularly we've independent sexual violence and independent domestic violence advisors, we know that support through the system helps to reduce attrition, so we've invested £41 million in making sure that there are additional sexual violence and domestic violence advisors. We've tried to protect as much as we can victims funding. Victims funding has increased substantially over the last sort of decade or so, and we've tried to particularly protect that funding with respect to violence against women and girls. So there are things we're trying to do, but the overall position, is not one that we think is desirable at all.
No, and I do want to come specifically to violence against women and girls. You've raised it yourself, but we received evidence from the Rape and Sexual Assault Counselling Centre, who make very clear that the short notice cancellations and postponements, often on the same day, are making the situation even more difficult. So not only these extremely long waits in very distressing circumstances, which are having obviously profound impact on victims who are waiting, but also making it very difficult for those, as you say, who are supposed to be there to support these victims and preparing them for trial, and then suddenly only to find out on the same day that they're not being listed. So what more can you do? You've said some of the things, but to try and both specifically reduce the very long waits for people with this category of crime, where obviously it is incredibly distressing to be living with the fact that your perpetrator is potentially continuing to perpetrate these crimes against other women, and you may find it very difficult to be able to even just get on with your own life in the interim. But also, what more can you do in general to stop these sort of short notice cancellations and postponements, which also add to the distress of victims?
So, I mean, Daniel or Nick may want to pick up on some of the things with respect to the listing. So, listing obviously is for the independent judiciary. We are incredibly supportive of all the measures that they are putting in place. If I can refer to one in particular, for example, initiative that they've launched in Bristol, where they have identified 4 courts out of 10 that they are going to focus specifically on violence against women and girls and adult rape, and that appears to have, that we have an evaluation of it, but it appears to be making a bit of a difference overall. I think just the previous senior presiding judge was very focused on the very long-term cases, so he put out a practice direction with respect to cases that have been in the system for 2 years or more. So there are a number of initiatives we're putting in place. The nature of the backlog, the size of the backlog, and the timeliness means that it's not as I say, it's not a particularly desirable situation. I don't know if Nick or Dan wants to talk about listing.
I was just going to make the point that you've done, Jerome, about the senior presiding judge's initiative, where rape cases over 2 years were effectively prioritised last year and listed. That exercise has now concluded, and in terms of the point about the cases being stood out on the day, yes, of course, it's terrible for all involved. The sort of situation that the resident judge and the listing officer face is they have to, by law, prioritise those cases that are in custody, and that sometimes involves some very difficult decisions as to what cases should be stood out. So, yes, I fully accept it's traumatising for all involved, but the volume of custody cases in the system and the need to prioritise those custody cases by law is a thing that's driving, one of the things that's driving this.
And can I just probe, is there any data to show how many of those cancellations to deferrals are actually people who've given video evidence? Because there's some suggestion that in these cases, particularly very vulnerable victims are actually giving video evidence because of their vulnerability, but from the point of view of the courts, there seem to be easy ones to defer. So you were just saying there that priority is given to those in custody. Are there any other evidence of different types of cases being more likely to be ones that are delayed?
There is a criminal practice direction based on a case, R versus Barker, which states that cases involving vulnerable or child witnesses should be routinely prioritised. So, I can't speak for every judge in the land, but I'd certainly like to think that those cases are not seen as easy ones to stand out, and that they are getting the priority they deserve.
And if I may, just part of the rationale for introducing the Section 28 measure, which was about pre-recorded cross-examination, was specifically to enable the bringing forward of the date of cross-examination. So that was the intention behind the measure, one of the intentions behind the measure.
Okay.
Just come in on both the answers that Mr. Glass and Mr. Flury have given. Firstly, a 54% attrition rate. I've taken an interest in these serious sexual cases, both in this committee and in questions in Parliament, is shocking, and you say the figure is going up. People who, as Ms. Dixon said, have gone through this horrendous ordeal often, then to have their cases postponed for 2 or 3 years is a pretty poor state of affairs. And then, so no wonder that so many actually drop out. They just simply can't face going through the whole court system. So what more can be done?
So can I just on that particular point, it is a lot of that attrition is obviously pre-court. So that doesn't mean there are lots of court measures that we are putting in place, but it is a whole system. Part of the work that we were doing under what was then the rape review, where we set targets particularly with respect to increasing referrals from the police to the CPS, increasing charges by the CPS, and increasing receipts into court, was particularly to look across the whole system. There are, as I say, there are some measures we've been taking with respect to courts in Section 28, the work the judiciary are doing, but it's really important that we do this as a whole criminal justice system thing, not just a courts thing.
So I'm coming on to that. I'm just going to ask Mr. Flury this question. Some of the things that we're talking about are really very simple things that your department ought to be, through the judiciary, ought to be able to take a very severe attitude to. Things like not getting the suspects to the court on the day that they're supposed to be there by the prison service. Things like the barrister not turning up or not getting the case prepared on time. I mean, these are sort of intolerable things in a criminal justice system that's already severely delayed. So what more can your department do to these relatively simple things to correct them?
Well, in terms of those points of efficiency, the committee may be aware of something called the Crown Court Improvement Group, which is a group led by the senior presiding judge, which brings together all components of the criminal justice system, whether it's the prison escort, custody services, police, the bar, and so on. And this is the forum where they discuss these what I'll call bread and butter efficiency issues. Why hasn't the van turned up? Why aren't you ready when you said you were going to be ready, and so on. That, of course, needs to translate down to local level as well. And I know resident judges in all Crown courts routinely meet with chief Crown prosecutors and their local bar to tackle these issues firsthand. The system is certainly not deaf to, these issues that, if I'm honest, have been around for some time, but need constant tackling. And the initial Leveson review sought to do some of this, which eventually turned into the principles of better case management. And, I'm hoping that the subsequent Leveson review will further endorse and enhance some of these principles to improve efficiency.
Sorry, Anna.
Yes, I like you, Chair, just did really want to probe on that really shocking figure of victim attrition. And whilst, I hear you saying that is a wider issue, not just specific, but clearly for victims of violence against women and girls of sexual nature or rape, the idea that you're going to have to potentially wait 1-2 more years to actually even have your opportunity to, have your case heard, will be extremely off-putting to people who fear speaking up, fear even taking their perpetrators to court. So I suppose I would just ask, perhaps, Dame Mayor, if you would just comment in general on the what is being done to specifically tackle long waits and support victims, what more can be done to ensure that victims in general are getting their opportunity for justice.
Yes, of course, and I know that Jerome wants to come back in. So the first thing to say is you're absolutely right that every number in the backlog is a victim. And we never forget that what we're talking about is people with real-world impacts. So we're doing a huge amount of work on this. Listing is a judicial function, and as Dan has set out, we have been very supportive. We're working closely with the judiciary. We've been very supportive of judicial initiatives to focus on this. For example, in the previous senior presiding judge's direction that all RASO cases over 2 years should be listed by summer 24. So these are things that do make a difference, and they're changes in listing that we do not control, but we work with in other initiatives such as the ones that Jerome already set out. I would say two other things. One of the things that we do know that does affect victim attrition is victims being supported, and that is why we have maintained investment into ISVAs and IDVAs, so independent sexual violence advisors and independent domestic violence advisors, because having that support is one of during the process of waiting, which is obviously unsatisfactory, but nonetheless at the moment is part of the system is really important. And the other thing that we are very focused on is transparency. So we do publish this data. We have the dashboards that the Chair has already mentioned before, the criminal justice delivery dashboards, where we look at a local level at a number of these things, including victim attrition, because of course the first step is to shine a light.
We'll be coming on to technology in a
okay.
Yeah.
Right, I'll stop there.
This is an incredibly important subject, but I'm afraid we're just going to have to move on now. And Rebecca Paul, please.
Thank you, Chair, and thank you to the witnesses for being here today. We've obviously just talked a little bit about victims, and now I just want to move on to focusing on those that are accused, specifically those that are on remand and in custody. So from the report, we can see that the remand population has reached around 16,000 at the end of 2023, which is the highest level in 50 years. Now, 2/3 of those are awaiting trial. And I have to say, I'm pretty new to this. It's the first time I've really looked at this in any detail. And I was pretty horrified to realise that there are people that haven't been found guilty of anything that are spending years in prison and then may even come out at the other end and be found innocent. But firstly, before we get into that, can you talk to us a little bit about the interaction of the prison population and how that impacts, obviously, what you're trying to do? Because obviously I understand it is affecting the processes. So if you can maybe lay that out for us, I think that would be really helpful, because that will give us greater context about my big concern.
Great. Well, look, thank you for the question, and you're absolutely right. So the criminal justice system is a whole system, and it's a very complex system, and there's a very close interplay between the outstanding caseload and what's happening in the Crown Court and the prison population. And the way this most obviously presents is via the remand population. So we have seen, in fact, as of September 24, it's now 17,600 is the remand population, and this is now 20% of the prison population, and that is up from 9,602 in September 2019, which was then 11% of the prison population. Now, why this matters, apart from a number of other reasons about remand, and you've already mentioned some of the issues, which is if you're awaiting remand, some people are on remand awaiting sentencing, some people are on remand awaiting trial. You've already noted some of the issues around that. One of the important issues is how we run the prison population. We can hold certain prisoners in certain types of accommodation. So prisoners on remand can only be held in certain types of establishment. So that makes it a much higher proportion of the prison population on remand, makes it also harder for us to manage prison capacity issues and to manage that prison population. So a number of reasons why this matters, and of course one of the most important things in getting the remand population down, and I can talk a little bit more if you like about all the things we're doing like the bail information service and so on, but one of the key things is the sooner we can get the backlog down, the more we can get the remand population down, because there is a direct correlation, as you would expect, between the number of cases in the backlog where there is a defendant, in many cases, awaiting trial, and the remand population, because some proportion of those defendants awaiting trial will be held on remand. So the whole thing is linked, and it's also, and people often talk about a tension in the system between what's happening in the courts and what's happening in the prisons. This is an example of essentially everything is leaning in the same direction, which is the more we can get the Crown Court backlog down, the more we will be able to better manage the prison population. So things like the thing we have most recently done in this government has created the headroom through policy decisions on the prison population that created the headroom to allow us to put the magistrate sentencing powers, extend magistrate sentencing powers, which is helping, we think, to be determined, we think will help bring down the Crown Court backlog, but you've got to have the headroom in order to be able to do that. And so the whole thing works together. You build the headroom somewhere, you can make a change on the Crown Court backlog in a way that then helps you overall manage the prison population better, and that is good for the whole system.
Okay, no, thank you for that. And it will be good for you to talk to us a little bit about all of the different things that you're looking to do on this. So what is the custody limit at the moment for a defendant on remand?
What's the custody time limit?
Daniel covered it some before. 6 months is the custody time limit. To keep someone in jail beyond that requires a judge to make a determination that that is required. It's for that reason that those cases are prioritised. It is incredibly rare for someone to not have a trial and be in jail for years. There is a reference in the NAO report, I think it's on page 48, that talks to this.
Paragraph 3.14.
Sorry?
Paragraph 3.14, page 48.
Now, the Ministry in subsequent, they quote a parliamentary question, the Ministry in subsequent parliamentary questions has clarified that the data's not fantastic on this, but we have looked very hard when that information came out to see if that was the case, and what we found is it is extremely rare. The cases where people are still in jail without a trial of that sort tend to be where they have, for example, already been convicted of one offence, but there are other proceedings waiting to happen. They tend to be very, very complicated cases. So I think you get the wrong impression if you thought that was a very common occurrence. But the data isn't there to absolutely...
Mr. Goodwin, I wonder if you're underplaying this slightly, because if you look at that paragraph 3.14, it says that 32% of the remand population were being held beyond the custody time limit. That's 770 people. But 5% of the remand population had been on remand for more than 2 years. I mean, any system that can hold somebody on remand for 2 years who might be completely innocent, there's got to be something seriously wrong, isn't there?
770 people that works out as. And that's 770 people that have got families, they've lost their livelihoods potentially as a result of this. It has as much, but, there's the whole human impact.
Yes.
So,
did you manage to hear that? I mean, basically, what Rebecca Paul was saying, that 770 people whose family lives themselves, and their family life has been put on hold for 2 years or more, and they might be totally innocent.
There has been subsequent clarification of the parliamentary question. So I do, though, take the point. Whether there's 770 people now, I couldn't tell you with confidence. But the law is structured so that those that are on remand do get the hearing within 6 months, and it is a judicial decision on the facts of the case whether that is extended or not. And so that is the protection in law. Whether it's 770 at this point, I can't comment. Clearly, any delay is
well, it's such a serious matter. Would it be possible for you to get us an up-to-date figure, the best figure that your department thinks it should be, thinks it is, because it is such a serious figure? And then I think we really would like a little note as to what can be done to prioritise those over 2 year cases, because I think it is really absolutely shocking.
I completely support the chair on that. I think it would be good to have that breakdown of these cases that are over 2 years. In fact, I would say, over 6 months, to be honest with you.
Yes.
So that we can actually, you've obviously set out that it's quite rare and there are other factors going on. But I think if we could see the data behind that, that might give us some reassurance, or will certainly highlight any groups where we do have a real concern on this.
Ms. Romeo, could we have a note on that?
Yeah, so
it would be really, really helpful. Thank you.
Yes, certainly.
Thank you.
And also, just to come back on Ms. Paul's question about some of the things we're doing. So, because one of the things, of course, some of this is about what's happening in the court, but some of it is just what we're doing with that remand population. So, just to remind the committee that we've implemented a dedicated and very proactive bail information service in all courts and reception prisons. And we're recruiting officers we're currently recruiting and have recruited a number of officers for that. So this is to make those remand prisoners aware of how bail works, because in some cases they might actually be eligible for bail. And then also we are increasing community accommodation service provision, which is essentially, sometimes it's hard to get bailed because of homelessness problem. So the more we have community accommodation service out in the community, then the more we can, homelessness is reduced in being a reason that people are remanded, because we've got nowhere to bail them to.
So just to follow up, Ms. Paul's really important questions. And you've given us the figures, which are that there were 9,000 people on remand before the pandemic. There are now, according to the latest estimates, over 18,000. So that's a doubling of the number.
Just under 18,000, I think.
Okay. We won't argue over an odd 100 or two. So that's a doubling of the number of people on the remand. And when you look at that paragraph that the NAA have produced for us, which says in the middle of the paragraph, in 2022, 35 of those remanded in custody awaiting trial did not ultimately receive a custodial sentence, including 13% who were acquitted entirely. I'm just wondering if there's any way that these cases where people have been waiting on demand, whether it's for 2 years or whether it's for 6 months, could be prioritised, because we haven't yet got on to the pressure on the prison places system. But if you could free up some of that number on remand, that would, and as you said, it has a disproportionate effect on some prisons that house a lot of these remand prisoners. It would actually ease some of the pressure in the prison system considerably.
So, yes, absolutely, and we spent quite a lot of time discussing this. So again, obviously, listing is a judicial function. The fact of the custody time limits, and as Nick said, you can't stay in prison beyond your custody time limit without a judge having made that decision. And so therefore, Nick will correct me if I'm wrong on any of this, therefore they are prioritised to that extent. Obviously, there's a number, as per Ms Dixon's question, we're also encouraging of the judiciary in their initiatives to prioritise RASO cases. There's a whole raft of that. In a way, yes to prioritisation. Got to be careful not to try and prioritise everything. I'm not saying it's not an absolutely essentially important issue, and we are supporting the judiciary on this. I should also say, obviously, the reason that the remand population has come up, just as I was saying previously, so significantly is because you would expect it to come up significantly as the backlog has grown, as the outstanding caseload has grown.
Thank you. And just my last point. So I have found this really eye-opening, I have to say. And I sort of think about if I were in this position where I were accused of something, and what might I do? I've got children, I've got a life. Is there a risk when the reality of the matter is that you could end up in prison for 6 months before you get to the point where you can have your day in court? Is there a risk that people are putting in guilty pleas in order to avoid being in the situation where they're held in remand for such a significant amount of time? Is that something that is arisen? Do you have any concerns about that? Like the fact that, this pressure could potentially change the approach that people take to their plea?
So what I would say is that long waits are bad for everybody. They're bad for the defendant, they're bad for the victim, they're bad, they're inefficient in the system. So there's all the effort that we're doing to reduce the timeliness problem and to speed up, to improve efficiency, but also to increase capacity in the court system to deal with this, is aimed at getting those weights down. Obviously, everything in a way is conceptually possible because you're talking about individuals making decisions. We did, under the last government, there was the early guilty plea task force, which was actually looking at some of the incentives to put in guilty pleas, because in fact we've actually got often the opposite problem, which is we don't have as many guilty pleas, or we have a lot of late guilty pleas, and we'd obviously rather those guilty pleas appeared earlier, because that would also help the system. So the whole guilty plea issue is quite complex, but I acknowledge the problem that you identify.
There's something else which is worth understanding, which is not all the cases in the backlog are backlogged cases. So even if the system was operating at optimum capacity, quite typically going back pre-COVID, a case will take 6 months to get on. And in some circumstances, someone might be remanded, and that is because that is the typical length that the trial preparation takes between prosecution and defence, and to get a trial ready, even in fair weather. So I don't want you to believe that that's necessarily massively changed. But as Antonia says, the more people that plead guilty, and we do look to be getting back to people pleading guilty to a similar rate to pre-COVID, is actually quite a healthy thing for the court system.
I wonder what more can be done on an incentives side to encourage, if they're going to plead guilty, to plead guilty earlier in the trial. And I'm also wondering to what extent some people game the system by pleading not guilty, hoping that their victim will go away. So I just wonder, this would speed up the system considerably if you could get more people to plead guilty earlier, would it not? And what more can be done?
So yes, it would. I think we just got to be very careful with incentives, because with the situation we don't want to get into is precisely the one that Ms. Paul was referring to, where people are feel in some way pressured or in some way kind of pushed towards guilty pleas, and this is. There are any number of examples where, the most recently with the Post Office Horizon cases, I know that there are people who felt sort of under pressure to plead guilty, and that's very much something we want to avoid. That said, all things being equal, it is completely right that although the sort of the overall guilty plea rate and not guilty plea rate haven't changed, the point at which people are pleading guilty has shifted. And people are pleading guilty much later in the system, later on. And
I'll ask one question.
Of course, Andy Slaughter.
One thing that wouldn't be seen as undue pressure would be if prosecutors could, at an early date, indicate within sentencing guidelines what the likely sentence would be for a guilty plea at that stage. Yeah. Now, is that happening? Of course, you're not responsible for the CPS. That might be part of the problem, but I'm sure you work closely with the Attorney General's office and the CPS. Is that happening? Because I suspect that with quite a few defendants, if they knew that either they would like to get a non-custodial or short custodial sentence, they might well plead guilty early.
So the direct answer, I think that's a question for the CPS as to whether it's happening. Can I give you sort of my what? There are two things that's worth bringing out. The first is that was very much a focus of the first Leveson review in 2015, about making sure that people were getting the cases prepared quickly and getting advice in to their to clients kind of at the right point. And so therefore we would expect Leveson to look at that, how the system kind of comes together to make sure people are getting the right advice at the right point. Just one thing we have done is that one of the things that we are concerned about is just making sure that people are getting advice early, and that is why we talked a bit earlier about criminal legal aid, and in particular putting advice into the duty solicitor scheme. There has now been a sort of, we're arresting the trend of a reduction in the number of duty solicitors, and I think that is a positive thing for making sure that solicitors are getting, that people are getting advice early on what pleading at first hearing means in terms of discounts and so on and so forth. So I can't speak to the prosecution point, but I can speak to what we've done on the criminal legal aid front to make sure that people are getting advice early to help.
Thank you very much, Mr. Glass.
Can I just come in on this very brief point?
Yes, you were due to come in anyway. Yes.
Oh, right, sorry, okay. Just really to underline the point about the impact of waiting on defendants, I spoke previously about victims. I have a constituent in my area who has had many rescheduling of his trial, and it's impacting on his family life in terms of contact with his own son, which is obviously incredibly distressing. In order to try and reduce sort of disruption to family life, obviously another option rather than blocking up prisons, if you're saying 20% of people on remand, what is being done about more remand into the community? I mean, we hear about community tagging and different things. Is that something that you see as part of the sort of solution in terms of the relationship between the courts, the waits for trial, and the prison population?
So again, I mean, obviously sentences are a matter for the judiciary. I think what we can help with is making available things like tags that mean that there is a kind of alternative in community punishment, electronic monitoring, etc., that is available to the judge if they wish to sentence into the community rather than into custody. But I wouldn't really want to comment on actual sentencing policy. I should say, just also slightly in the interest of time, we're back in front of the Committee on Prison Capacity within a month. Right. So I'm expecting that something like that may come up then.
I'm conscious that there are many levers, not all obviously within your direct influence or jurisdiction, but clearly you do have a role and responsibility to make sure that all of these different levers are working together.
Absolutely.
So the only final point, which I do think is relevant to backlog, is the consistency, so geographical variation. So Bradford Crown Court, where I am, I think is the 15th worst in England, Wales, in terms of the backlog. So how do you ensure sort of greater consistency in terms of things like your productivity, comparative wait times, numbers of delayed or cancelled sitting days? Where does that fit in terms of you addressing these backlogs in terms of geographical variation?
This is an excellent question and one I'm going to ask Dan.
Sorry, I just threw it. Thank you.
You're right to say that there is quite considerable geographical variation across England and Wales, and there are a number of Crown Courts that are performing relatively well, places like Hull and Oxford and Carnarvon and so on, whereas there are others, primarily in London and the Midlands and the South East, that are in greater difficulty. Capacity is the principal reason, and that capacity can be multiple things, whether it's the local bar, judges, the building. Those are the things that principally drive performance of a certain Crown Court. What are we doing to tackle that? So there have been a number of initiatives. So firstly, when deployment of judges is a matter for the judiciary, but I know the judiciary take these performance variations, bear them in mind when they are making deployment decisions. Secondly, we're looking at how technology can allow us to move cases around the country from those where there's little capacity to more capacity. So there's limitations of what we can do in the Crown Court in relation to technology, but there are opportunities to move certain types of hearings to somewhere else to ensure that they can make progress. But we routinely come together, HMCTS and the judiciary, to talk about how we tackle capacity challenges in certain regions, how we can move judges around. We had an initiative during COVID which was called Judges on Tour, where a number of judges came down from the North East to help out in London. But it's things like that we do in order to ensure that there is a degree of evenness across England and Wales.
Okay. I don't think we had data in the NAO report on variation, but if you are able to follow up and perhaps give us the geographical variation in backlog data.
And it's all so you can there's a lot of data available at local level on these data delivery dashboards, so we can definitely send the link to the committee, but lots of it's there.
Really helpful, thank you.
Thank you, Chair.
Oliver Ryan.
Thank you, Chair. The contribution that Mr. Flury just made sort of touches on my point, really. So perhaps with specific reference, Dame Antonia, to London and the Midlands and the South East in particular, do you have enough judges? Because what my worry is that through this we've heard that there aren't enough solicitors, there aren't enough barristers, there's no capacity in the system, demand keeps going up. There seems to be a bit of an institutional acceptance that there's always going to be a backlog because you're running at full pelt and you've been running for full pelt for 3 years. Do you have enough judges?
So first of all, I don't want to describe an institutional acceptance. It's more running at full pelt within the available resources is what we can do, and considering and constantly pursuing efficiency and looking for opportunities for improvement. So we're ambitious to do that. The judicial capacity is not a constraint at the moment, but you're absolutely right, Mr. Ryan. We have had over periods times when it was, and I already referred to we've had a major recruitment of circuit judges and recorders. And the most recent circuit judge recruitment, we actually recruited 10 more circuit judges than we had originally that we had vacancies for. So we're seeking to overshoot in order not to have the problem on judicial recruitment you identify, and obviously, as we've already discussed, the work we're doing to ensure we've got counsel and so on. I mean, it's a constant endeavour to make sure that one has all the capacity, both in terms of judges, in terms of the professions, and then in terms of the physical capacity. At the moment, we're not reporting a lack of judges, but again, it's something, I mean, we're about to do, we've got a review, we've got another round, I think, on recruitment happening at the moment, and obviously future rounds will be subject to what we can afford to do in the SR and decisions by the Lord Chancellor.
That's the answer I'm looking for. That's okay. That's good. Do you mind if I just spread out slightly on that?
Can I just
of course,
come in on the back of your question? As you hinted at in your answer there, there's a bit of a trade-off, isn't there? Because when you're recruiting more judges, you're actually reducing the number of barristers. So it is a bit of a juggling act, isn't it?
Well, the thing is, you give yourself flexibility by, for example, the existence of recorders as a concept, and by definition, then you're looking in the pool that you're fishing in, if I can use that analogy, then is drawn from. So it is all, again, it's all connected. Yes. But which is why we have to. We try never to forget the other parts as well. So when we're focusing on judges, we are also thinking, what is this going to mean for the professions? You're absolutely right, Chair.
Thank you. Oliver Ryan.
Thank you, Chair. If I could just touch on a slightly broader point, I suppose. You mentioned before there's no silver bullet to some of these problems, and I understand that you're dealing with a capacity problem, despite running at full pelt, and you're doing a good job in doing that. You're just not managing to get through this backlog. But there's been a lot of mention of Leveson, I think, in everybody's answers as we've gone through this. Leveson's come in, and that's fine. But it does feel like we're banking on that to deal with a lot of these changes. We've mentioned Leveson to deal with the bread and butter issues like case effectiveness and preparation, for Leveson for overall capacity, for Leveson for wholesale reform of the criminal justice system, for Leveson for increasing capacity in solicitors and barristers, for most things. Which almost sort of leads me to say, what was the plan pre-Leveson? And if we're sort of starting afresh off the back of Leveson, are we not just kind of managing failure until that comes? And I know that's kind of a bit of an odd example for the question, but that's what it feels like to me.
A fair question. I think the reason we've all been focusing on Leveson is that's the thing that is looking independently at big policy reform for the future. But as I started out by saying, there's a huge amount that's been happening already. So when we start with, as in the conversation I was having previously with Mr. Slaughter in this session, you look at the demand coming in, the capacity, and then everything you can do to maximise that capacity, and then to get the throughput through that. So that's the kind of basic model. So in terms of maximising capacity, the physical capacity, all the work we're doing on the physical estate, all the work we're doing on maintenance to improve the estate, the relocation. I mean, actually, the Fleet Street relocation obviously isn't in crime, but there's a huge amount that's happening all the time to try and improve the physical estate. Then there's what we're doing on judicial capacity. So that is the recruitments that I mentioned, but it's also things like judicial pay that has been significantly increased in the last 2 years, the judicial pension scheme that we looked at. Yep. There's the retirement age. We raised the retirement age. So there's constant things happening to try and increase the capacity at every level. Then there are the policy things that we can do within our current operations. So magistrate sentencing powers is an example of that. And then the overall thing that we're doing is whenever we find money, we constantly keep the budget under review. And the Lord Chancellor has been really clear, additional money found should be put towards tackling this problem. So when we had a small fluctuation in our budget emerged at the end of last year, we were able to fund an additional 2,000 sitting days. So we are now going to be funding overall 108,500 sitting days for this year. So we're constantly seeking to do things to tackle this problem.
My worry is that if we're not careful, spending too much reliance on Leveson, that we'll be sitting here in a year or two's time with the system having got worse because we're still thinking about what to do in Leveson's results. So what sort of reassurance can you give the committee that I think Mr. Goodwin said that Leveson's going to report in the spring, that real urgency will be given to thinking about whether to implement his and we don't know what they're going to be yet, of course, but we've got to, all of us, work towards improving the system. What real urgency will there be considering his proposals and implementing them?
So again, two parts to Leveson. So the bit that we'll report in the spring is going to be the sort of longer-term policy reforms, of which a number of things already set out in the terms of reference.
Well, the intermediate
we're
courts
considering.
come into that.
Yes, that's that sort of thing. I don't want to prejudge the report, but those will be then decisions for policy decisions for ministers whether we're going to pursue those, and we would then seek to obviously consult and implement as swiftly as possible. The thing that's then happening later in the autumn will be the kind of look at efficiency, which we also think is incredibly important for reasons as described in response to Ms Dixon's question, which is why do we have such a big disparity of disposal rates? How are we going to get the disposal rate back to where it was pre-pandemic? Issues like that.
I suppose what I'm saying is, actually the efficiency things are the easier things to implement. You could be doing some of that work now. Why are we needing to wait for Leveson?
We're not waiting at all. In fact, we are doing it. It's only that we're wanting to accept challenge and acknowledge that there's always more that can be done, as well as all the work that we're looking for. A lot of this work is being brilliantly led by the senior presiding judge in the Crown Court Efficiency Group, which is literally looking, as Dan said, at why didn't the van turn up? How can we get more efficient here? Why is this court doing differently to this court? All that work is happening across the system, involving HMCTS with led by the SPJ and the Crown Court Improvement Group. All of that work is being done already. I'm just saying we also want to say, because Sir Brian had previously done a report in 2015 that led to a number of recommendations on efficiency, which we implemented, come back and test us that we did implement them as effectively as we might have done, and let's do more if we can.
Right, well, we've got that all on record. We shall see how it all pans out. Nesl Calliston.
I look forward to coming back.
You'll be back?
Yeah, I know.
That's a promise. Nesl Calliston.
Thank you very much, Chair. And I must say, I welcome the commitment around the everyday improvements. I would say these are just things that should happen well. A well-run organisation, any organisation, does the business as usual stuff well, and it lays the foundations for trust and confidence that there can be any fundamental change in the future for what will be ongoing demand. I welcome that commitment. I want to focus a little bit on monies already spent. So we spent some time looking ahead. I'd like to look back. Because I do think it's important that the committee is able to probe on value for money, particularly as I think the coming months will present an opportunity for there to be lessons learned so that mistakes aren't made again. The NOI report lists some of the measures that the department took to deal with the backlog after the 2021 spending review. And we've spoken about some of that already, including things like the cap on sitting days, increasing the number of judges, and introducing Nightingale courts, which is what I will focus on. But I would argue that those things haven't worked because of the increased numbers. It's failed, basically, in my view, and at best it's been inadequate. By July 2021, my understanding from the report is that there were 72 Nightingale courtrooms. A huge expense to the taxpayer, and that these type of courtrooms were costing something, in some cases, up to 6 times as much as a normal courtroom would cost. And I think that's in the NOI report around page 32. By February 2022, the Law Society was very clear that it was a huge cost to the taxpayer. It had cost £34 million by that point. And to date, I think actually by 2023, it was £78 million. A huge amount of money, huge amount of taxpayers' money for a system that isn't working. The purpose of the courts were a temporary measure. That's the first thing I wanted to check. There has been a reduction in those courts. That's the second thing I wanted to check. We currently have 20. Was it a temporary measure? And what is the projection for those 20 closing?
The situation has changed quite rapidly. So there are still Nightingale courts in operation. In the Crown Court, which we're looking at today, there are 9 Crown courtrooms still in operation. And the reason we've been able to wean ourselves off is Nightingales were required during COVID and while we were under COVID restrictions because the physical space required for courtroom was extremely different. So we have come off most of the Nightingale courts, and one of the reasons we've been able to do that while increasing the number of courts that are sitting to a very, very high level is that we're making better use of our permanent estate, and we have created more permanent estate as we've weaned ourselves off Nightingale courts. So, for example, if you look over the river at Southwark, we've turned the canteen in Southwark into a proper Crown Court, and that therefore reduces the amount of Nightingale space that we need in London. So we've been very, very alert to the VFM
Weren't Nightingale courts set up to deal with the COVID situation? And therefore, why have they continued to exist for 3 years?
I'll give you an example within London. So alongside, so that we are trying to get more capacity into the system generally. We've also dealt with other shocks. So in London, for example, we had Harrow Crown Court, which is one of the biggest Crown Courts in London. It's got 8 courtrooms there. We had RAC, Bubbly Concrete, and we've had to close that court for a long period of time. That is part of the reason why we've kept open some of the Nightingale estate in London. So it's not as simple as saying it's just a COVID measure. There have been other factors in place. It's the same, and this is less to do with the Crown Court, but the Magistrates Court and the Civil Estate up in Lancashire. We've been hit by a lot of RAC in Lancashire, and therefore we have Fleetwood Magistrates Court or Fleetwood Court open to allow us to maintain the capacity in that area. So it's not as simple as just saying.
You view the Nightingale courts as temporary measures?
Yes, the Nightingale Court is a temporary court. Yeah.
Because they are very expensive, aren't they? So you have, for example, I think in Croydon, the Leonardo Hotel. Since I think over the past year, it's almost £3 million has been spent on them, and I just want to understand, because putting COVID aside, there are some longer term challenges about the existing estate, and is it really the case that the Nightingale courts are temporary measures, or actually should you be building this kind of cost into your baseline?
We're not doing that. We are constantly reviewing whether they need to be kept on. I mean, the rule of thumb is they're 3 times more expensive, okay? They're not all 3 times more expensive. There are some buildings where we have a peppercorn red. It's an old court. If actually they're relatively cost efficient to run, but certainly the ones that you highlight that were in London were very expensive, and we've been weaning ourselves off that. So they do remain temporary. We do review them all the time. I don't know, Dan, if you want to give any more.
Yeah, I think once Harrow reopens, then we will look again at the courts in London, Barbican, and in Croydon. But just to give a bit more detail of the courts Nick mentioned, we have a court in Cirencester and a court in Chichester. Both are on peppercorn rents, and whilst they were initially established to support the continuation of jury trials, they're now principally used to support or provide capacity in face of other estates difficulties. For example, we had to shut Guildford Crown Court this year for a new roof. The court in Chichester allowed us to maintain capacity and output in the South East.
So these things, so this is the point I'm making. There will always be things that arise because of an estate. So I used to be a council leader, in London. We had a vast estate across the borough. We would put in capacity in our planning that assumed some things would go wrong. And what you've described to me are things that go wrong. So is it a fair assumption to make that there will always be something like Nightingale Court that will be at a premium cost to the taxpayer, given that things will always go wrong in terms of an estate?
We're always looking, I'll give you another example. We are opening a new Crown Court next week in Redditch in the West Midlands, and that hasn't been badged as a Nightingale. That is something where we've taken an existing court, we've made some adaptations to allow us to increase capacity in the Midlands. I agree with you that we need that capacity and the flexibility, but I don't agree that it comes at exorbitant cost. The Nightingales in Chichester and Cirencester, we're talking thousands, tens of thousands in terms of the cost of these sites. So, we do have a degree of flexibility.
So overall, and I'm not making a value judgment here, I'm just asking the question, the cost of £78 million on the Nightingale courts that was spent was value for money?
We couldn't have operated jury trials during COVID had we not had Nightingale courts.
Slightly different question. Is it still value for money?
So we've...
Did the department do everything possible to make sure that as money was spent to be able to deliver those courts, which is critical? Because you can't... Money is not always the solution, as we've heard, but also the reality is everyone has to live within their means. And every official has to make sure there is value for money. And the purpose of this committee is to probe and say, you were given £477 million. If you were given £600 million, would you have spent the £600 million? Or would you have actually said, actually, no, we're going to try and deliver more value for money and spend it less?
We've consistently looked at the value for money of keeping the Nightingales on. We've done that in relation by looking at the requirement in each area. We've done it in consultation with the local judiciary. What we've been seeking to do is make sure that we can sit our allocated sitting days, because we want to get through the Crown Court backlog. We need to get through family and civil cases. Where we would not have been able to do that, absent Nightingale, we have looked to see what other alternatives there are. Southwark Canteen, Telford, really good examples of where we converted temporary estate to permanent estate, and only where there's no other option of being able to sit those sitting days would we maintain.
I guess what I'm asking is, are you happy with the approach and the formula that you take when you are commissioning this additional capacity? Because fundamentally it hasn't worked, has it? There is still a backlog, and it's fair to say, you're commissioning them. There might be value for money, but if you were given more money, would we still have a backlog?
Well, can I perhaps say something on that? So I think it's not quite right to say it hasn't worked because there's still a backlog. In a world of constrained resources, backlogs can exist, and it doesn't mean that the way you have spent the money has worked. The question is, what's the counterfactual? But just to reassure Ms. Caliscan, all accounting officers have to review spend against 4 tests in managing public money. One of those tests is value for money. So for the Nightingales to be, and indeed to make a business case to the Treasury to do these things in the initial sense, we have to test ourselves against value for money, propriety, regularity, feasibility. And Nick will do that as accounting officer for HMCTS, and then I will look at it as the principal accounting officer. So by definition, the judgment has been made to spend this money.
With all due respect, that's what I'm asking you. That's what I'm probing.
Which is why I'm applying.
Is that judgment correct, given that we still have a backlog? And that's what I'm asking.
Well, I suppose the question is, so what is very difficult, again, conscious of time, but what's very difficult in making these value for money judgments is, what is the value? So to Nick's point, we could not have kept the Crown Court system going through COVID without Nightingales. So the value judgment there was that we could keep the system going, and we kept it running with that spending that money on Nightingales. That was the judgment. I think you could disagree with the judgment, and I think
we want to round this off because we've got a little bit to go yet. But to just sum up Ms. Callison's questions, if you look at paragraph 2.7 on page 32, the average courtroom cost of your own estate is $280,000 per year per place, whereas the Nightingales have ranged up to 1.6 million. So they have been very expensive. And that, I presume, is why, Mr. Goodwin, you're running them down now. So just on a more general question to round this off, because we've got MOJ, if you look at paragraph 3.6 on page 50, MOJ estimated 50% of Crown Court courtrooms were at risk of closure at any time in 2022, as to where we've got to at the present time. Now, you've mentioned the Southwark major project. There are others mentioned at paragraph 2.8, 2 major super courtrooms in Manchester. So it must be a backlog for a balance between maintenance of your existing courts and these major projects. Are you constrained by resources in either doing the major projects or maintaining your existing court estate, bearing in mind the NAO reckon the backlog is about £1 billion?
So we do have a maintenance backlog. We've spoken about it. The Justice Secretary, the late Chief Justice, spoke about it. It's a significant maintenance backlog. We have been awarded better settlements over recent years, including the last settlement we had for the maintenance backlog was 220 million, and not spread over 2 years. That was incredibly important because that actually having 2 years is so much more powerful in terms of value for money, being able to achieve value for money than having it in a 1 year cycle. So that was a big improvement. But we do still have a maintenance backlog, and we still have a big risk with our courts because they do go wrong even if you don't have COVID or RAC. What I was projecting before was the fact that because we have a little bit of capacity around the system at a national level, we are incredibly adept at moving cases so that we do not lose sitting days. And when we look at our objectives, it is to sit the days that we are allocated because there are costs to us, there are legal aid costs, there are costs on the prosecution. They are extremely expensive to run a Crown Court trial. And if we lose those days, it is difficult. So we do everything we can to move them. New projects, we have significant big new projects coming. Of course, I would like lots of more new projects because most of our Crown Court estate in particular is Victorian in nature. They are huge, big, expensive buildings with very few courtrooms in them, and they are expensive to run. But we do have some good projects coming, so that we've particularly good one coming in the City of London, which is going to be a big flagship court. And so, yeah, we have some good investment coming. But there is a big backlog of maintenance. There's no two ways about it. And it requires a lot of management to get what we can out of the system at the moment.
We, just for the record, Mr. Flury, we are delighted to have a court in Cirencester, offering it to you at Peppercorn. Please keep using it for as long as you wish. Mr. Ryan, Oliver Ryan.
And Burnley. Just very, very quickly, do you know how many cases were dealt with through the Nightingale Courts programme? Do you have a number for that?
So I haven't got the number off the top of my head. Can I just give you a bit of context?
Yeah, if you can. Just a note. If you can do this for a note afterwards, that's fine.
Yeah. It's a lot of Nightingale's court were not what you would think of as a typical court. So quite a lot of what was different in most Nightingale courts was they did not have custody suites. So what they were doing is they were hearing some trials where you had a defendant that you didn't need custody suite for, but they were hearing quite a lot of, if you like, auxiliary proceedings to the main criminal trial. So that I'm saying that to give you, they are quite different, and therefore the mathematics of adding up how many trials they heard would be slightly different.
It's probably quite. I understand that. A note would be great. It's just a quick. It's probably just a quick
just have a note.
Calculation to just say if you didn't have the Nightingale courts, how many more cases would you have had to have dealt with through the current system, and that would be helpful to know.
Thank you very much, Mr. Ryan. Pete Fortune.
Thank you, Chair. Just very quickly on that point, I've been looking at some of the data on this. The infrastructure failings within the courts really is an issue, isn't it? I'm just looking at the data today. There's 103 out of the 516 Crown courtrooms aren't sitting, it's about 20%, and Nottingham has just closed for the day because of health and safety. So this is an ongoing issue that you're having to deal with, isn't it? And I think that just puts a lot of that in context in terms of how we're dealing. But I'm talking about police numbers, and I know we've talked about this through the conversation today. So just to benchmark very quickly, can you sort of set out what impact the increase in police numbers has had on the Crown Court backlog? I know we touched on it, but just to reset the benchmark.
So obviously they're one, of many, but they're one factor, but they're a really significant factor. And as you'll know, the total number of police officers in March 2022 was 140,000, and in March 2024 it's now 148,000. So these are really significant additional numbers. And also one of the key questions is not just the number of police, it's the fact that at the beginning they've got to be trained up. Yeah. So what we're finding is there's more police, they're trained now, and also it depends on what they're focusing on. So if they're focusing on either areas where there's a lot of throughput or really difficult and complex cases, these are all things that could have a significant impact on the system. And this is why one of the reasons why receipts have gone up so much, as set out in the report.
I guess people would consider it axiomatic. You get more police officers, you're going to have more cases going through the court. But is there a sort of, in terms of future expectation, and I don't want to stand on your toes, Clive, when you've got these new police officers coming in, what kind of cases are you expecting them to deliver to the Crown Court?
So, and that is, of course, a crucial question.
Yeah.
So the way we model, because obviously we are trying to model receipts into the courts so we can do all the preparation and set up capacity and so on, and what the police will spend their time on, i.e. what is the case mix going to be, is one of those crucial assumptions. So we agree with the Home Office what those assumptions will be, because obviously we're heavily reliant on the output of our modelling. So those inputs, those will be inputs, and we do agree them with the Home Office each time when we're running the model.
Because what I've been busy doing now is looking at that increase in police officers and then looking at the trials that have been through and convictions. And if you look at something like murder convictions, if you look at that number of police officers, if you look at the number of cases that have gone up, that doesn't really pull through to the number of murder convictions or the increase in murder convictions.
Well, murders is a slightly...
I'm picking one particular...
No, I know, but it's a sort of
so.
problematic one because it's, mercifully quite a low number. What I think is interesting, if you look, for example, at violence cases overall, there's been a dramatic shift. And in fact, I'd say the most pronounced shift in over the last 10 years in terms of receipts into the Crown Court has been, whereas... in 2016, for example, there were 5,000 receipts per quarter against a sort of overall number of 30-ish thousand. In 2024, that was 10,000 against an overall sort of 30-ish thousand. So it's doubled. That's a massive shift in terms of where the police are. What's coming into the system. And so sex and violence cases are now a much bigger proportion of receipts than they were 10 years ago. And that flows through into the backlog. And because those cases understandably take longer, they're more complex, they require more hearing time. And so that is why when we say the backlog is is harder, that is what we mean in practice.
Peter, I'm going to have to rush you because we're running out of time. Clive Betts, thank you very much. Thank you.
Now the easy question. What will the backlog be in 12 months' time?
Well, I don't think it would be right to predict. We talked about this earlier.
Sorry, we've been talking about predictions and why they weren't met right the way through.
Well, we don't publish projections. What we do, as I said previously, I expect that it will be higher than it is now, looking at the rate of receipts and the rate of disposals.
You've had projections in the past. You've had ambitions to get it down to 53,000, which wasn't achieved. So that must have been a projection, wasn't it?
We don't publish projections of what the figures. We had an ambition that was set in October 21 to get it down below 53,000. We don't publish projections of what we think.
Ambition is not looked out of thin air, is it? It's based on some modelling.
Of course.
Right. So your modelling now would indicate what's your ambition for 12 months' time?
Our modelling indicates that absent significant additional policy changes or changes to the system, the number will be higher than it is now.
Right. So what are the constraints then? Because the reason that the figure of 53,000 wasn't hit, as I understand it, was due to disposals being less, not the number of cases coming in. So
no, receipts have gone up significantly. The number of demand has increased dramatically from the police, from the fact there was an additional...
Right, the receipts coming in. So your modelling then is showing that is the problem area, is it? The number of cases.
Receipts, demand is going to continue to grow and outstrip our ability to deal with that demand.
And so your projection about your capacity to deal with it is pretty firm, is it? You haven't got any...
Well, again, so because it's all about disposal rates, and as if the Lady Chief Justice was here, she would say judges spend a lot of time on other things as well as disposing cases. But the point is, at current disposal rates, we would not be able to keep pace with the increase in receipts, which is why the backlog is growing. Obviously, as discussed, there's a load of things that we can seek to do, including on efficiency, to try and improve that position.
53,000. The receipts in 23-24 were actually less than the receipts in your planning assumptions in 2021.
Sorry, can you...
Yes. In 2021, your planning assumptions, which led to the forecast for the 53,000, I understand it, were actually less than the receipts that you actually had in 2023 were less than your initial planning assumptions, which led to the forecast you didn't hit.
Yes, so receipts have outstripped even what we were predicting they were going to be. Is that your point?
No. They were,
or perhaps what's the question, I suppose, would be helpful.
No, they were less than you were in 2021, you were forecasting.
Well, that may or may not.
Well, it's quite important.
Well, 2021 was just
true.
Well, no. In 2021, receipts were 95,512. That would have been post-COVID, so it would be unsurprising. Coming out of COVID, predictions of receipts as we were recovering the courts was obviously harder, but projections are projections. Forecasts, we seek to the point that Mr. Fortune was making, we seek to project to predict what receipts will be based on things like how the police might spend their time, numbers of police, other things. Those are not necessarily guaranteed to be exactly spot on. We obviously seek to improve them. This is why we work with the Home Office and what the assumptions are and what the police are spending their time on.
If I may, Mr. Betts, part of the complication, as I was sort of alluding to, is not just the number of receipts, but what they, as the Permanent Secretary, is what those receipts are. And that flows through into something that we've talked about, which is the disposal rate, the number of cases dealt with per sitting day. So if you want, it's a kind of loose way of thinking about productivity. Because the mix is harder, each sitting day is buying you less sort of disposals and fewer trials, if you want. And so that has also changed. So that shifted from pre-COVID to now. So if we could return to pre-COVID levels in terms of the disposal rate, we would be seeing much more inroads into the backlog.
Just to give a bit of colour to what Jerome was saying, if we've got much more complicated, heavy cases coming through the system now, and they are much more likely to proceed to trial. If a case proceeds to trial, it takes 10 times the time of a case that does not. And what we now have is a lot more trial cases.
So fundamentally, the way that you do things is broken, because what you're saying is even if there wasn't an increase in the number of cases coming through, you would still see an increase in the backlog because of the cases. The nature of the cases are complicated and take longer.
I'm not sure that necessarily means. I think what you said, what we're doing is broken. You have to repeat the beginning of your point. The point we're making is there are two things happening here. There are a number of receipts, and I've now understood, Mr. Betts, the point. You're referring to this on page 26.
Yeah.
This point, right? So, and that is to be, as you'll see, that then post-COVID. So I will return to your point. Post-COVID, the number, it was harder to make forecasts accurate. I mean, we didn't know. We were planning for what we thought receipts would be. We were coming out of a pandemic. We were making predictions about police numbers, what they were going to be focusing their time on. As you'll see, it's getting more accurate. I'm not going to say it's always perfect. It's not always perfect. We try and improve it to make the forecast as accurate as possible because we've got to deliver against those.
So I'm going to draw that bit of it to a close. I just want to ask one or two questions about technology and the common platform, and then I'm going to give the last question to the Chairman of the Justice Committee. So I'm very happy, unless you want to answer these questions now, Ms. Dame Romeo, I'm very happy you let me have a note on this, because these are sort of pretty straightforward technical questions, really. And this is to do with data, and why were the processing and coding issues with the common platform not identified before the new system was rolled out? Why did it take so long for the issue to be identified and rectified? What more are you doing to ensure the accuracy of the Crown Court data, and how long it will take to implement? What confidence do you have in the reliability of the common platform, and what confidence do you have in the accuracy of the caseload data in other parts of the criminal justice system? And I'm very happy, if you don't want to answer that now, if you give us a note, whichever you choose.
Well, I mean, I'm happy to say some. I mean, we can comment now if helpful on the common platform, but perhaps I could comment on the. And I'll hand over to Nick and Dan to talk about the common platform, just in terms of the actual data on the Crown Court backlog. So, as you'll know, we did identify an issue caused by three factors that meant that we did pause publication of the backlog data from June to December. That was as a result of case records affected by human error, technical systems issues, and data coding issues. We did two things. Once that was identified, we looked at and Nick may want to say something more about this, we operationally checked that the numbers were being inputted and how they were. But I also commissioned on behalf of the Lord Chancellor an external review, which has determined that we can have a significant level of confidence in the Crown Court data, because obviously when an issue like this arises, you do then want to check and do an audit. So we have done that audit. In response to your final question, I think we can be now confident in that data. The other thing that we have done that Nick might want to talk about is Nick took the opportunity of this period to align the data through the One Crown programme, which meant that we had a bit of an issue with multiple data series capturing the same thing between management data and official statistics. That has now been brought together and is aligned. So I think that gives us another reason to be confident in the quality of the data. Nick, do you want to say about Common Platform?
Well, yes. So, I mean, you can have confidence in the data. The amount of checking that we've done on it, having discovered not what we expected, is really extensive, and you can have confidence in the data. On Common Platform, Common Platform has vastly improved over the last few years, partly down to Daniel's efforts and others. It is now a good and stable system. It does allow us to pull a lot more data off it, and will become more and more valuable as it goes on. So it's a much more stable system. In respect to the Crown Court, Common Platform is in all the Crown Courts, being used by all of the Crown Courts, but we took a decision to bring Common Platform together with the other critical Crown Court system, which is known as DCS, which is how people access the actual information in the court. And we took that decision largely because we wanted to make sure that we weren't introducing new risk into the Crown Court of a brand new IT system that fundamentally changed different ways of working at a time of fragility when we wanted to as throughput as possible. That's proved really successful, I think, and we'll now build on that and make sure that we have a really good IT system in the Crown Court. I think we have made good strides.
So just round this up. Can we be assured that you are not resting on your laurels in this technological stuff? I would imagine there's a lot more that could be done by better use of digital and AI and things like listings and case preparation and so on. So can we be assured that there's somebody in the department working under you who is actually considering these matters?
You can certainly be reassured of that. We have made a big leap forward in terms of our digitalisation of the courts, and it now lays a foundation for a lot more potential, including very measured, careful AI, but we are looking at it very hard.
Dame Antonia, we were always very critical in this committee, but I think actually when you found the problems with this data, actually you are to be commended, because it was a big lot of work to put it right, and it sounds as though you've now got on top of that, so well done on that. I'm going to give the final question to Chairman of the Justice Committee, Andy Slaughter.
Thank you for your indulgence and your hospitality. I shall come again if asked, but it's
there may be an opportunity before too long.
I know. In deference to you being a figure-based committee, can I ask for two figures, very quick questions? One is, what's the latest listing date you currently have in the Crown Court? I heard yesterday about a bail case, fraud case, being listed in 2028. Is it right? You're listed in 2028, and how, or even beyond that? Second, you mentioned several times as one of the inefficiencies the deliveries of prisoners to court. What is the date, the cut-off date by which Serco has to deliver Serco has to deliver prisoners by? I heard it was 4 p.m, which is the end of rather than the start of the court day, before there's any penalty.
So I'm going to ask Dan to do the first of those, and probably the second, but it's certainly not 4 p.m. But
the answer to the first is it depends. If you wanted a bail trial in whole Crown Court, you could get one in August of this year. But I can say there are trials being listed into 2028. But I should say that there are sometimes usually reasons behind that. So, for example, they are waiting for a preceding trial to finish, to conclude, to allow another trial to take start. But there are trials being listed into 2028.
Okay. And Serco, what's the date?
When do they get a penalty if they don't deliver?
It's 11, isn't it?
I think I'd like to come back on that. I want to say 12 o'clock, 12 noon, but I'd like to check and establish that if I could.
I imagine there'll be a period, there'll be a sort of MOU agreement, an SLA. There'll be a SLA agreement, and then there'll doubtless be a penalty time. But we can come back to you on that.
Let us have a note.
Shall I bring it back when we come? When I'm next in front of the committee, or just right?
I think if we could round up all the issues that we want to note on today, because we've got to produce a report on this hearing rather than wait for the next one. Otherwise, we'll get a serious backlog in this committee, which I'm very anxious to avoid.
Quite right. Jerome wanted...
Yeah, Chair, maybe I provide one figure that you have asked for earlier at the start. You asked for a number on civil legal aid, in particular how much the additional spend of the 10% on housing and immigration. I can tell you that is going to be in steady state will be £20 million a year.
Very much.
Steady state.
That's very helpfully official. So, Dame Antonia, can I thank you and your team very much? There's been a lot of interest in this committee, in this hearing today. You've answered our questions. It's been a long session, so we're very grateful. And we look forward to hearing from you soon on prison capacity. An uncorrected transcript of this hearing will be published on the committee's website in the coming days. The committee will consider the evidence providing and will, of course, produce its normal report with recommendations which you will no doubt consider. So thank you very much.
Thank you for having us.
Order.